19th of 2023. In lieu of an invocation, we'll have a moment of silence, and that will be followed by the pledge. But before we get into that, I do want to recognize two special people who've been with us for a significant period of time, and I understand this is their last zoning hearing unless somebody during the duration of this meeting can convince them otherwise. But would like to honor Tim Pierce, if you can stand, please. And yes, and thank you for your service. And Mr. Carl Carver, if you can also stand. We thank you both for your service here during these hearings and helping to guide us through what tends to be our most enjoyable meeting of the month, probably one of our most challenging, but you helped to get us through it, and you both certainly will be missed. And again, we thank you for your service here in Cobb County. With that, we'll have our moment of silence again, followed by our pledge. Thank you. Go ahead and stand for our pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Our meeting is now called to order, and I'll turn things over to John Peterson, our zoning manager.
And thank you, Madam Chair and Board. Okay, today's hearing will be conducted with the following process and procedure. Each case will be called in numerical order. When the case is called, we would ask that the applicant please stand and raise their hand to show that they are in attendance. After that, we're going to call to see if there's anyone here opposed to that specific case. We would also ask that the opposition please stand and raise their hand so that they can be counted for the official record. After recognizing both parties, they will be asked to come forward to be sworn in so they can present testimony to the board. The applicant will testify first, and then the opposition, if any, will testify second. It's important to note that each side only gets 10 minutes to state their case or concerns. There is not a rebuttal process or a process to reserve your time, so you want to convey all your information to the board within your 10-minute time period. Additionally, if there's more than one person who wishes to speak on the issue, you may want to coordinate with each other about what you're going to talk about, because each side only gets 10 minutes and you don't want to cover the same information over and over. After that, the board will start to discuss the case at hand. From the discussion, they may ask one or more members of the public to come back to the front for additional comments or questions. After that, the board will start to discuss the case, and they'll make a decision to either approve, deny, continue, or hold the case. There is one case on today's, well, actually, there's 5 cases on today's agenda, which have been continued, and these cases will not be heard today. First case is rezoning case Z15 of 2023, SDP Acquisitions, LLC. This case was continued by the staff until the October 3rd, 2023 Planning Commission zoning hearing. So Z15 will not be heard today. Rezoning case Z30 of 2023, Quick Trip Corporation. This case was held by the Planning Commission until the October 3rd, 2023 Planning Commission zoning hearing. So Z30 will not be heard today. Rezoning case Z31 of 2023, Dwell Communities, LLC. This case was continued by the staff until the October 3rd, 2023 Planning Commission zoning hearing. So Z31 will not be heard today. And just as a side note to Z31, this case will be shown as withdrawn on next month's agenda. Next case is rezoning case Z32 of 2023, Toll Southeast LP Company, Incorporated. This case was continued by the staff to the October 3rd, 2023 Planning Commission zoning hearing. So Z32 will not be heard today. And finally, LUP 21 of 2023, Leslie Gonzalez. This case was continued by the Planning Commission until the October 3rd, 2023 Planning Commission zoning hearing. So LUP 23 will not be heard today. Madam Chair and Board, we did get a request late last week to continue Other business item number 40, Curly Family Homes LLC. The applicant would like additional time to talk to the community and address some comments. So the staff would ask the board to continue other business on number 40 until your October 17th hearing.
I make a motion to continue OB 40 to the October 17th Board of Commissioners zoning hearing.
Second.
Okay, any discussion? Call the question. The motion passes 4-0 with Commissioner Richardson being absent.
Thank you. Before we get going on the consent agenda, I do have two more announcements. I would like to ask everyone in today's audience, if you have a cell phone, please turn the volume off on your phones. When the phones ring, it does interfere with the broadcast and the presentations. And I want to remind applicants, opposition, or any interested party that information is due to this board the Wednesday prior to this hearing. Any information submitted after the Wednesday due date may or may not be considered by the board at their discretion. And with that, Madam Chair and Board, I'm ready to start the consent agenda. Cobb County Board of Commissioners zoning hearing consent agenda for September 19th, 2023. First case on consent is rezoning case Z33 of 2023. William D. Brown requests a rezoning from R20 to CRC for commercial and retail in land lots 789 and 790 of the 19th District. The property is located on the west side of Ernest Barrett Parkway, on the south and east side of Laura Brown Way. The Planning Commission recommends approval of Z33 to CRC, subject to the following conditions. Number one, all stipulations from rezoning case Z111 of 2000 to apply to this property. The applicant is present. Is there anyone here opposed to rezoning case Z33? No. Let the record show there's no one opposed. Rezoning case Z34 of 2023, Graydon Eric McWright request a rezoning from GC to NRC for light automotive and a specialty contractor cabinet design showroom and warehouse in land lot 2 of the 20th District. The property is located on the east side of Cobb Parkway, north of Autry Church Road. The Planning Commission recommends approval of Z34 to the NRC zoning district, subject to the following conditions. Number one, site plan received by the zoning division on July 7th, 2023, with the district commissioner approving minor modifications. Number two, fire department comments and recommendations. Number three, stormwater management division comments and recommendations. Number four, water and sewer division comments and recommendations. Number five, Department of Transportation comments and recommendations. Number six, site plan review comments and recommendations. Number seven, special exception for a specialty contractor for use as a cabinet design showroom and warehouse at 4946 Cobb Parkway. Number eight, no outdoor storage or outdoor displays of merchandise. Number nine, no wrecked or inoperable cars to be kept outside. Number 10, site plan to include the uses for each building and to include any prohibited uses. And number 11, if the Board of Commissioners approves this request, any change to the exterior of the building or to the uses come back to the BOC as an other business item. The applicant is present. Is there anyone here opposed to rezoning case Z34? No. Let the record show there's no one opposed.
Yes, Commissioner Gambrill.
I would like to make a few changes to the stipulations that were just read into the record. For number 10, I would like to delete as it's currently written and replace it with 4948 Cobb Parkway to be used as light automotive only. Then on number 11, strike if the Board of Commissioners approves this request, and start with any change to the exterior of the building or to the uses shall come back. And those are my only changes. And I also did verify this with the applicant prior to reading them into the record.
Okay, thank you. Okay, moving to land use permits on the consent agenda. LUP 20, West Cobb Office Investors LLC, request a temporary land use permit renewal for a dance studio in land lot 241 of the 20th District. The property is located on the west side of Kennesaw Due West Road, south of the convergence of Kennesaw Due West Road and Stylesboro Road. The Planning Commission recommends approval of LUP 20 for 24 months, subject to the following conditions. Number one, if the dance studio use is discontinued, then the land use permit ceases. Number 2, Planning Division comments and recommendations. And number 3, Department of Transportation comments and recommendations. Is the applicant present for LEP 20? Is the applicant here for LEP 20, West Cobb Office Investors? Is there anyone here opposed to LEP 20? Madam Chair and Board, the applicant is not present, and there is also no one here opposed to this.
John, this is a renewed LUP. They've been there for many years, correct?
Correct.
I'm willing to leave it on the consent
All
agenda.
right, thank you.
Thank you. And John, before you continue, typically when we read in additional stipulations, I'll ask if the applicant's amenable to those changes, and I didn't do that for the prior application.
Yeah, and Commissioner Campbell did state that she ran those 2 changes by the applicant, and they were okay with it.
And the applicant is here. Okay, I see a thumbs up. Thank you. Appreciate that. Okay.
Okay, moving into the other business cases on the consent agenda. First case is other business item number 39 of 2023, which is to consider amending the site plan for 7 Oak Stables LLC regarding rezoning application Z79 of 2022. The property is located on the southeast side of Cooper Lake Road, west of Civitania Road, and land lots 257 and 320 of the 17th District. Staff recommends approval, subject to the following conditions. Number 1, elevations received by the zoning division September 13th, 2023. Number 2, stormwater management comments contained in the other business packet. Number 3, Cobb DOT comments contained in the other business packet. Number 4, fire department comments contained in the other business packet. And number 5, all previous stipulations not in conflict with this amendment to remain in effect. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to other business item number 39? No. Let the record show there's no one opposed.
Madam Chair, I'd like to add, include an amendment.
Okay.
And this is just for clarification because there was an elevation that was submitted on last week, Thursday, I believe, and the architectural design slightly differs from what was submitted in December of 2022. So I just want to make clear that the design should be consistent. So with that, I'll include an amendment to read that the district commissioners to approve the final architectural designs of the barns. Okay.
Okay, thank you.
All right. Moving on to the next
And
case.
those who are watching, I got a thumbs up again from the applicant, so there's
Okay.
agreement. Thank you.
Thank you. Okay, next case is other business item number 41 of 2023, which is to consider amending the stipulations for South Crescent Realty Partners LLC regarding rezoning application Z116 of 2004 for property located on the south side of Crescent Parkway, southeasterly of Herodian Way, in land lots 878 and 916 of the 17th District. Staff recommends approval, subject to the following conditions. Number 1, Exhibit B contained in the other business packet. Number 2, fire department comments contained in the other business packet. And number 3, all previous stipulations not in conflict with this amendment to remain in effect. The applicant's representative is present. Is there anyone here opposed to other business item number 41? No. Let the record show there's no one opposed. Last item is other business item number 42 of 2023, which is to consider amending the stipulations for Tyndall's and Allgood LLC regarding rezoning application Z173 of 1999. The property is located on the south side of Piedmont Road, west of New South Drive, in land lot 517 and 564 of the 16th District. Staff recommends approval, subject to the following conditions. Number 1, Exhibit B contained in the other business packet. Number 2, fire department comments contained in the other business packet. And number 3, all previous stipulations not in conflict with this amendment to remain in effect. The applicant's present. Is there anyone here opposed to other business item number 42? No. Let the record show there's no one opposed, and that completes the consent agenda, Madam Chair.
Excuse me, John, you do have a comment?
Yes, John, I would like to add that since this is allowing a special contractor, but we don't know who the tenant will be, I'd like to add that the use come back to the district commissioner for approval. Is the applicant okay with that?
He said yes. Okay, sorry.
Okay. Thank you.
Thank you.
And that completes the consent agenda, Madam Chair and Board.
Okay, are there any other changes needed to our consent agenda? Okay, seeing none, Commissioners, I move that we approve the consent agenda as it has been revised.
Second.
Are there any other questions or comments? Call the question. The motion passes 5-0.
Madam Chair, I gave my statement to the clerk.
Thank you, thank you. So Commissioner Burrow's statement is on file, and Commissioner Gambrill? Okay, hers is also on file. Thank you. For those of you who are here as part of the consent agenda, the Board of Commissioners did approve all of those matters, so you're free to leave at this time unless you'd like to stay and observe our other zoning cases. All right, John, I think most have cleared.
Okay, moving into the held case agenda. First case we're going to hear today is LUP 18 of 2023. Heli Lopez requests a temporary land use permit to allow more vehicles than the code allows in land lot 261 of the 18th District. The property is located on the north side of Crevice Road at the terminus of Wanda Lane. Is the applicant present? The director of the applicant is here. Is there anyone here opposed to LUP 18? We have one person opposed. All those who wish to address the board, please come forward and be sworn in.
Any in support?
Is there anyone, thank you. Is there anyone here in support of LUP 18? Please raise your hand.
Okay,
It's just the applicant, Madam Chair.
okay, thank you.
Good morning.
Good morning.
Chairwoman, if we will, there's a problem with the timer. We're working on it with communications. If we can just let the speaker know you have 10 minutes, and then I'll let you know when you have 2 minutes left if you look at me, okay? I'll try to let you know that, or CP will let you know that next to you, okay? In the meantime, we'll hope to get the timer up shortly, okay?
Thanks, Bill.
Okay, good morning. I'm Haley. I'm the applicant for these requests.
Ms. Haley, you are soft-spoken, and we'd love to hear your presentation. If you can help us in just leaning towards the mic.
Yes.
You're welcome.
Okay. So we're requesting 4 vehicles because we're 4 people driving, not 4 adults. My brother is 17, but he goes to high school. I go to college, and I drive about an hour away to get to college. My parents both work. We're not really on schedule. We don't have the same schedule. So trying to get my brother on our schedule to try to get him to school, or he also has a part-time job, it's kind of difficult for all of us. So just because we have different schedules is the reason that we're asking for 4 vehicles to be allowed in the property. Another reason is because currently my car is at the mechanic shop. So right now I'm driving my dad's car. It's kind of difficult to get around and get to school. Currently just having problems trying to work with 3 vehicles, but that's really a reason that we need 4 cars. I guess another reason I could say is because if right now I'm not financially stable to move out of my home, for them to just have those 3 vehicles in the property, I just started college, so it's a little bit difficult financially for all of us. But yeah, that's about it.
Thank you. Appreciate that.
Can I stop?
All right. You can be seated, and if the commissioner has any questions, she'll call you back up. Thank you. We'll now hear from opposition. Again, just note that the timer isn't functioning.
My comments will be very brief, thank you. I'm Steve Young with the Mapleton Improvement Coalition. We are, in fact, generally supportive of this LUP. We only ask that, in addition to the stipulations, that there are a number of pavers in the front yard. We'd like them pulled up and the yard replaced, and if that's not workable, just have the driveway widened and extended to accommodate all the vehicles. We just want to make sure that cars are parked on a solid surface, not on the yard. And I believe some of this is outlined in the letter we submitted earlier to the board. So that's all my comments. Thank you very much.
Thank you. I believe those were the only two that were sworn in. So Commissioner Sheffield, I'll turn it over to you.
Okay. May I have the applicant to approach? Just for clarification, you mentioned that there are 4 or 3 adults at the property and one, and your brother is, excuse me, he's 17.
Yes.
And he accounts for the 4th person?
Yes.
Okay, all right. Also, how many vehicles are currently parked at the property?
There is 4 vehicles.
4 vehicles?
Yes.
Okay. Are any of them work or commercial vehicles?
No.
No? Okay. You mentioned that your car was in the shop. Once it's repaired, would that be a 5th vehicle at the property?
Oh, I'm sorry. That's the 4th vehicle, but there's
That would
3
be
of
the
them right
4th
now.
vehicle? Okay. Okay. Okay, thanks. That's all I have for the applicant, unless you guys have anything.
Yes, ma'am, and certainly, we have some questions about the number of vehicles, because if you look on the screen, you'll see more than 4 vehicles parked there. I know your request is for 4. Are you familiar of other vehicles being parked there for an extended period of time?
No.
No? Okay, maybe this is an older GIS photo.
There were extra vehicles in the past, and then we got rid of those.
Okay.
Yes.
All right, thank you, ma'am.
Yeah.
Are there- Okay.
And just for clarification, this is an old photo. I did a little digging. It's a photo of the spring of last year.
Okay.
But to your point, this has come before us as a code enforcement violation, because at one point, there were a number of 12 vehicles parked at the property.
Right.
And it seems like over time, the vehicles have decreased in the number that's at the property. It appears that there is the driveway is sufficient in length to house 4 vehicles. Is there a particular reason in the past that you have parked or cars have been parked on the grass?
No, we just started parking on the grass because we didn't want like the extra vehicle to like be sticking out. So that's why we kind of parked on the side. I'm sure the guy who gave us a ticket, he asked for the replace the paving that connects to the driveway just so the 4th vehicle wouldn't be straight on the grass. That's why that's there. But if it needs to be removed, we can do that.
Okay, so the driveway can comfortably fit how many vehicles?
I'm
Without
sure it
it,
can-
without it sticking out in the street or in the right-of-way?
It can fit 3 because we have 2 trucks.
Okay, so it would fit 3, and you would likely have to park 1 on the road?
Yes, ma'am.
Okay, all right. Okay, thank you. Does anyone else have anything for the applicant? No? Is code enforcement here, by the way? No? John, maybe you can fill in this blank for me. John? Do you know when the last code enforcement inspection was on the property? Based on the attached in the file, it appears that it was June of this year, but do you know if there's been an inspection since that date?
There's not been one past June, because once they file the application, code enforcement puts a stop to all inspections until they hear something from the board.
Okay. Okay. Yeah, go ahead.
So there's no garage?
No.
Okay, so what are you going to require that they all be on hardened surface?
Pardon?
What is going to be required so that they are all on a hardened surface, not grass, the four cars?
Yeah, stipulation that it's to be parked on a hardened surface.
Okay, but there was talk about widening the driveway or taking up the pavers or something?
Well, that was a request from the opposition to impose that stipulation. And based on the applicant's testimony and there being what seems to be a financial hardship for the family, I'm just not sure if that's something that they may be prepared to do. I mean, obviously, I can't determine that for them, but I am prepared to include a stipulation to ensure that the cars will not be parked on the grass. Yeah, I know. Any other questions or comments from my colleagues? No? Okay. I mean, it appears that, just based on the driveway in this photo, it appears that all four vehicles can be parked in the driveway. There is no garage, nor is there a carport at this property. But I will make my motion. And obviously, it will be on, right, there you go, yeah. Okay, all right, so that will be in the DOT right of way, okay, at the end of there, okay. All right, just a few comments, and, you know, this has come before us. This has come before us as a code enforcement issue, and apparently the initial code enforcement violation dates back to April of 2023. And it took approximately 7 to 8 months for the owner or the applicant to come into compliance with code enforcement after several visits to the property and also a court date of May of this year. By all accounts, there's been a willingness from the county to work with the applicant to ensure compliance at the property. But unfortunately, based on the number of visits with code enforcement and the non-compliance, there seemed not to have been a willingness on the part of the applicant as they continued to park vehicles in the grass and also stored tires and other items, including car seats, at the front of the home. The code allows for 3 vehicles and 3 people pursuant to the square footage of the property. The application's request is for 4 vehicles and 4 people, which I do not find to be an unreasonable request, particularly in these trying times for families. And with that, I am prepared to make a motion. I make a motion that LUP 18 is approved with the following conditions: that it shall be approved for a 12-month period. The applicant is to submit another land use permit application for consideration before the end of the 12-month period if there is a desire to continue to have more vehicles parked at the property than the code allows. At no time shall vehicles be parked on the grass. All vehicles are to be parked on a hardened surface. If on the property, vehicles are to be parked in the driveway. No outside storage of any items except for firewood and lawn furnishings. And all other staff comments and recommendations not in conflict. And that concludes my motion.
Thank you,
Second.
Commissioner. We have a second. Are there any questions or comments?
I would just say a maximum of 4 related adults. And be a maximum of 4,
Well,
because we didn't say
But-
related.
well, we didn't say related, and I'm not going to put that restriction on. I'm comfortable with there being 4 adults at the property and 4 vehicles. Right, I understand what the code
If
reads.
if she doesn't emphasize that in her stipulation, that doesn't modify our code. Our code still stands.
Right.
So she doesn't have to articulate that again in her motion.
Thank you.
Yeah, it would be implied. So we have a motion and a second. Are there any other comments or questions? Call the question. Oh, excuse me, I apologize, Commissioner. Before we take your comment, let me just ask our county attorney how I handle that. If I call the question, I didn't see her hand for a comment for our vote.
It's fine for you to continue the discussion. Yeah.
Okay.
As long as we had a problem with that.
Okay, Commissioner Gamble.
I just would like legal to weigh in on this. You know, the question of do we have to specify that it's 4 unrelated? I was looking through here for the LUP application, and I wasn't seeing it in my packet, but does the LUP applications specifically state they're related?
Yes, the very
Okay.
last page of the packet, the
Okay.
worksheet the applicant submitted stated that there's 4 related adults in that.
Okay, so with it not being specified, it would still default back to the
Exactly.
application then? Because it's that gray area that we like to not get into, but with it not stating it's related, with the stipulation that Commissioner Sheffield put forth, would the county code still be applicable since it kind of went silent even though the application said it was related?
No, I mean, this would be an exception. This would be a special, allow for 4 cars to be there, whether they're related or not, so.
So if the comment was made that it would default back to the county code, that would still be applicable to no more than 2 unrelated adults. But if the motion and the stipulation is that you can have 4 vehicles and they don't have to be related, doesn't that circumvent county code?
Well, I'm sorry. I'll let
Let's
you
have
answer.
some order of one person to speak at a time.
Well, it'd be helpful, Commissioner Sheffield, what was your
No, I
intention?
didn't indicate that they did not have to be related. I did not make that indication. However, I did not reiterate that they have to be related because her application, the submission, is for 4 related adults. So there was no need for me to repeat that in my motion.
So in essence, it sounds like that what she wants to do is approve the application. The application is for related, so.
Okay, thank you for the clarification.
Thank you.
Thanks.
And let's just be mindful, irrespective of the specific stipulation, when we approve any zoning matter, we don't necessarily read the entire application to have it be relevant to the motion. So if she's approving the LUP, it will be my assumption, Bill, that the terms of the application that are being approved would be on the table.
Yes, besides any stipulations they would add to it. And because she did not welcome Commissioner Burrell's stipulation, then I think the question came into play at that point in time.
Okay. This would make for a very lengthy hearing otherwise. With that, we have a motion and a second. Are there any other comments or questions? We'll call the question. The motion carries 5-0. Thank you, Commissioners.
Okay, next case we're going to hear is rezoning case Z29, Grace of Georgia Properties LLC, who request a rezoning from R30 to RSL for a residential subdivision for 55 and older active adults in land lot 893 of the 19th District. Property is located on the south side of Morris Road, west of Hiram Lithia Springs Road. The applicant is present. Is there anyone here opposed to rezoning case Z29? Okay, let the record show there's no one opposed. Would the applicant please come forward to be sworn in?
Good morning, sir. You may begin when you're ready.
Thank you, Madam Chair. Good morning, Madam Chair, Commissioners, to the COP planning staff, and to the citizens in attendance. My name is Artegas Newell. I am a Director of Planning with DLBP Urban Planning Specialist. We are located here in Cobb County in Vinings on Paces Ferry Road, and we specialize in preparing rezoning applications for owners and developers and helping to design their projects. This is an interesting place for me to be at this side of the lectern. As I told the Planning Commission a few weeks ago, until recently I worked in public service for many years. Most recently I was the planning director for the city of Rome and Floyd County, just a little bit northwest of here, for almost 6 years. And prior to that I was the zoning administrator for Carroll County, Georgia, which is home for me, for almost 19 years. So I appreciate the time and effort of the commission, the staff, and I do appreciate the opportunity to be able to speak before you all today. And with that, we are ecstatic to present to you all our project known as Spring Lake Village, which is set to deliver 110 high-quality single-family detached homes reserved for citizens aged 55 and older, which is located at 3950 Hiram Lithia Springs Road. And we are respectfully requesting a rezoning from R30 to RSL Residential Senior Living. We are representing Grace of Georgia Properties in this request. Madam Chair and Commissioners, more detailed information is found in our planning opinion, which is located in your packet. However, throughout this presentation, we hope to show several things. One, how this proposal supports a housing need for Cobb's growing 55-plus population, how the proposal is supported by existing infrastructure and utilities, how we plan to mitigate traffic and stormwater, how this proposal compares to R20 OSC, and finally, we want to share our engagement with the community and their support for this project. By 2050, the Atlanta Regional Commission projects there will be a 128% increase in the number of citizens in the metro area aged 55 and older, thus highlighting the need for housing geared toward seniors. This allows people to age in place and to be near family and friends, and supports a vital land use element of the Cobb County Comprehensive Plan that calls for a variety of all types and densities to meet a growing and diverse population. The chart that you see here is not just a chart with numbers, but it's also reflective of our moms, our dads, our grandparents, our cousins, our friends, our church members, our neighbors who are here in Cobb County and are wondering how they will be able to stay here at home while being able to have a home that is suitable for their changing needs. Spring Lake Village is designed so that residents can age in place. The single-story detached homes with smaller footprints and are easier to maintain. Additionally, the amenities of Spring Lake Village create a sense of place and offers close proximity to medical, retail, dining, and other services, creating a wonderful community benefit. Spring Lake Village has direct access along Morris Road, and we will be in compliance with Cobb DOT's requirements for road and access improvements as outlined in the staff's comments. We did have a preliminary traffic study conducted which showed a minimal impact to the existing traffic volume, such that Cobb DOT agreed that a full traffic study was not required. Additionally, stormwater will be managed on-site, and our total impervious surface area will only be 26%, well below the 55% which is allowed under RSL zoning. We have met with several staff members representing different departments and received general good feedback as shown in the staff report. Comments from Cobb DOT, fire, stormwater management, water and sewer are all agreed upon in our stipulations letter. And overall, there is more than adequate infrastructure to support Spring Lake Village. Staff has recommended, and the Planning Commission as well, that our request be deleted to R20 OSC. So we have undertaken what R20 OSC will mean to the development of this property. Spring Lake Village will simply be less intensive than an R20 OSC development of this size. An R20 OSC development would have 310 bedrooms, and RSL would have 220. An R20 OSC development would have 248 people, whereas an RSL would have 165. An R20 OSC development would have almost 9 bedrooms per acre, and RSL has 6. In short, RSL will be far less impactful to the existing neighborhood than R20 OSC. RSL zoning is needed to create smaller lots that are easier to maintain while simultaneously allowing residents to age in place in homes at the desired lot sizes and square footages for those downsizing from their current homes. Spring Lake Village supports the spirit and intent of the Cobb County Comprehensive Plan. Zoning does not operate in absolutes, but is quite nuanced, and all considerations must be given equal weight when evaluating a zoning decision. We have undertaken a comprehensive outreach effort to keep neighbors informed about Spring Lake Village. In addition to the required sign posting and letters to the neighbors within 1,000 feet of the project, which includes neighbors in Paulding County, we hosted an on-site community meeting in May that was well attended, including by Commissioner Sheffield. Neighbors were able to see the proposed site plan, ask questions, and give their thoughts on the proposal. We adjusted an earlier site plan version based upon suggestions received from neighbors at the community meeting. We have made periodic checks to the site to make sure the signs are still up and visible, especially considering the storms as of late. We have received some calls and emails, and citizens have again been in favor of the proposed RSL zoning. Neighbors stated they were in favor of the RSL zoning as it is less intensive than R20 OSC and fits better into the fabric of the community. We also developed a website where citizens could view the site plan and submit comments. Additionally, we have an online petition which has approximately 20 signatures in support of Spring Lake Village. Commissioner Sheffield was quite gracious in letting us present Spring Lake Village twice during her in the zone meetings, and we also have comments taken from those meetings which will be used to adjust the final details of Spring Lake Village. Additionally, a letter of support was received to the commission by a neighbor that was, I believe, sent directly to Commissioner Sheffield and then distributed it. Commissioners, for these reasons set out and for those as outlined in greater detail in our plan and opinion, we respectfully request your favorable recommendation of and approval of RSL for 110 lots as submitted. I will yield the remaining time to any neighbor who would like to speak in favor, and thank you so very kindly. I will say that my colleague Caroline Burnett, another Director of Planning, is here to speak as well should there be any other questions. Thank you so very much. Thank you, Madam Chair.
Thank you. Were there any persons here for opposition? No. I do see one hand up. Ma'am, if you want to speak in opposition or in support?
I just want to clarify, I am the property.
Ma'am, I'm sorry, you'll need to come forward, and let's have you sworn in.
Chairwoman, he did yield the rest of his time to those in support. So he has excuse me, a minute
Yes.
and 18 seconds for those in support. So I don't know.
A minute and 19 seconds?
Yes.
Okay.
So I don't know if this lady is support or opposition.
I don't know. We'll find out soon. Ma'am, are you here in support or in opposition to the application?
I'm in support as long as I can maintain my privacy because I have the property on the
Okay,
public.
okay, if you can state your name for the record, and
Certainly.
then you'll have a minute and 20 seconds to speak.
Barbara Willoughby.
Thank you, Barbara. Go ahead.
I am the property that is on the Paulding County side, and I do not know how close their trails are going to be to my property. I'm just looking to maintain my privacy and the ability of keeping people off of my property.
Okay. Thank you.
Thank you.
Appreciate it. All right, are there any other persons here desiring to speak? Okay, seeing none, Commissioner, I'll turn it over to you.
Thank you, Madam Chair. May I ask ask the applicant to approach? There are a couple of questions that I have for you, but before asking those questions, have you had an opportunity to meet with Ms. Willoughby?
I'm sorry, say again.
Have you had an opportunity to meet with Ms. Willoughby, the person that just spoke?
We may have met at the community meeting. I'm not
Okay.
sure outside of that.
Okay.
We may have met at the community meeting if she attended that.
Okay. Do you know where her home is in relation to your development? If so, can you just point that out to us?
Mrs. Willoughby, I believe your home is the one that is, so in the bottom. Okay, I'm sorry.
Wait a minute, I have a third speaker, and ma'am, I haven't seen you sworn in to be.
I was sworn in.
Were you?
Yes,
Okay,
ma'am.
all right, thank you, I apologize.
I'm sorry, and my
What
name
is your
is Caroline Burnett.
What is your name for the record?
Caroline Burnett.
Caroline Burnett, okay, and you're with the applicant?
Yes, that's
Okay,
correct.
thank you.
I apologize for that.
Okay, thank you.
Mrs. Willoughby, I believe you're the home, so where the mouse is hovering right now, if you move just northwest, that's your property line, that's correct. And Ms. Willoughby, I do believe that you submitted a comment through our website in May with some concerns about the locations of the trails near your property, and I believe you were also present at the community engagement event, and so we certainly understand those concerns and want to ensure that Ms. Willoughby does have that buffered area so that she feels comfortable. And so the first thing that we did is we did shift the trails further to the east so that they wouldn't be as close to her property line, but we're here to find an amenable solution as well, and so we are willing to work with this board and with Mrs. Willoughby to ensure that her concerns are addressed properly.
Okay. Ortegas.
Yes, ma'am.
Is the August 25th site plan the latest site plan submitted by your company? And the reason I'm asking is because I received revised comments from DOT and fire, subsequent to that date, so I just wanted to confirm whether or not August 25th was the date of your last site plan.
That is correct.
Okay.
So that is correct. To the August 25th site plan is the most recent. We did see those updated comments from Cobb DOT as well as from Fire. I believe Fire had adjusted their comments to reflect that The homes in the community will be single-story, and so there are some different requirements for single-story homes versus homes that are 2 stories from a fire perspective. And then we also saw Cobb DOT's comments. We have stipulated that the final site plan will be something that will require district commissioner approval. And so we know that there are some components of Cobb DOT's comments that we have stipulated that we agree to, and we will update the site plan to reflect that at a future stage.
Okay. And I had a question regarding the topography, and there are some comments regarding the topography captured in stormwater comments with respect to some areas being as great as 10%. And I was just wondering, what's your development plan, or how do you plan to utilize the slopes? This is a sprawling property. I believe it's like approximately 41 acres.
Yes, ma'am.
And you'll have amenities to include walking trails, et cetera. So I just wanted a little bit more information with how you guys plan to develop around the slope and considering the topography on the property.
Yes, ma'am. We will work closely with the land planners to make sure that the final design of Spring Lake Village is not only an attractive design, but also is environmentally sensitive. We are planners by trade, and we are very cognizant and sensitive to the land, and we want to make sure that the slopes are treated well. There will be some grading, obviously, that's needed on the property, but we will take every effort in working with our engineers, land planners, to make sure that there is minimal impact to the area. We want to make sure that stormwater and everything else is contained, again, on-site, minimized, and the land planning will be reflective of that, and we'll ensure that we'll have coordination with our land planners and engineers to do so.
Okay, thank you.
Yes, ma'am. Thank you.
I don't have any more questions for you, and that's in part because we've been meeting and talking about this development since May.
Yes, ma'am.
So I will turn it over to my colleagues for any questions of the applicant.
Are you still requested 110 units?
We are, Commissioner. Yes, ma'am. Thank you.
Okay, I just wasn't sure with the change, if that, with the revised site plan, if that changed. And then you also mentioned impervious. So the comments, I think, in our book are based on R20 OSC. So what is what's the impervious for RSL, John?
It's 55%.
Okay, and you're under that, you said?
We are, yes, ma'am, right at about half. We are at 26%.
Okay, and I know this is, I'll just have questions for Carl when he comes up. Thank you.
Thank you, ma'am.
John, I'm not sure if this is a question for you or for Carl, but the applicant is claiming that his site plan is taking up 20% impervious, but staff comments are saying 55% maximum, and it says impervious surface shown. So is it 55 or 26?
Based on the staff comments, it looks like the original plan may have been 55%, but I would defer to Carl if there's a different percentage.
But isn't that for RSL? I mean, OSC?
Oh, okay. And Commissioner Burrow, I understand your question now. In the staff analysis, the impervious surface shown, that's based on RSL, not the R20 LSC.
Right,
So if they were R20 LSC, the maximum impervious would be 35%.
35, okay, that's what I thought.
Okay, Commissioner Gambrill, are you done with your question?
Yes, I think it was just for clarification, because again, staff usually puts what is actually on the site plan.
And the revised
In the
site plan-
comments.
And the revised site plan does show 26.5% of impervious
Thank you.
For the RSL,
for the RSL
they're at 26?
and a half.
Okay. Well, that's good.
Commissioner Shaw.
That's it. Carl, you guys may be seated.
Thank you.
Hey, Carl.
Yeah, good morning. Carl Carver, Cobb County Stormwater.
You're smiling a little more than normal, a little more than usual this morning.
There's a glow.
We're really going to miss you. Thank you so much
Thank you. Thank you.
for all that you've done for the county. Okay, well, I have a few questions. Are there, and there are two ponds, on the property. Will there be additional detention ponds, or would those ponds in ponds in the open space be sufficient for stormwater?
They may be sufficient for stormwater detention, but not necessarily for water quality. There may be additional ponds required for water quality and treatment as a pre-treatment before the runoff gets into those existing lakes and ponds.
Okay. And I think I saw in your comments where there's to be a hydraulic study or some type of study submitted during site plan review?
Yes, at the time of land development permitting, they will have to provide the hydrology study, along with, I think in my comments, I had evaluation of the existing lake dam and an updated breach study of that dam, so that we can determine what effects it might have on downstream properties.
Okay. In the topography comments, I just need a little bit more details regarding the existing site drain, and I can read this to you if you can't recall it to your memory. But it reads, there is an existing ridge line from the northeastern corner of the property to the southwest. A large portion of the existing site drain directly into the existing along the western boundary line of the project. Significant off-site drainage basin areas east of the project site contribute to the existing on-site lakes. I just need some clarification on that particular comment.
Correct. The western side of the development drains into the stream along the western side of the property. And that's kind of where the topography is, and where they're probably going to have most of their open space areas for amenity areas. And they'll have to, respect the stream buffers and the floodplain areas in there of what they can and can't do in those areas. The offsite area to the east is what's supplying runoff to the existing lakes. So
Okay.
that will have to play into their hydrology study when they come in
Okay.
for their land development. They'll have to carefully analyze what drainage area is coming through those lakes.
Okay. Also, generally, when we have construction, particularly of this magnitude, there's concern with respect to any type of drainage during construction. But can you share, in your professional opinion, what type of impact the development will have on the stormwater during construction?
Well, a project of this size will have to go through a three-phase erosion control during the land disturbance permit process, and that's reviewed by the Cobb County staff, Erosion Control Division. They'll have to have temporary sediment ponds throughout, probably, to control their erosion during construction, especially during the infrastructure phase. So it's a lot of that is depending on their final grading plan
Okay.
during the land disturbance permit.
Okay. And going through the comments, I did come across those same points that you just made. Okay. I think that was all that I had for Carl. I'll turn it over to you guys for questions. Commissioner?
You asked what else?
Pardon?
You asked.
Let's go ahead and turn the mic on for
No,
Do you have any
I don't
questions?
have any further questions,
Okay.
but, well, just one. So if additional water quality ponds or detention ponds are required, once they go through plan review, that'll all be determined by staff at that time?
Yes, ma'am.
Okay. That's all I have.
Okay. I'm not seeing any other questions.
DOT. Let me look at the.
Good morning, Ligia Florim, DOT.
Good morning.
Yeah, they do. Good morning, how are you? I'm sorry, did you state your name?
Yes, ma'am.
Okay, thanks. I had a question, I'm sorry, I was engaged in a conversation. No, that's okay. Okay, so your revised plan, which is dated August 28th of 2023, item number 3, let me just grab that. Regarding the D-cell lane, your revised comments indicate that it was not reflected on the plan that you received. Can you share with us how short or how many additional feet will be required for the D-cell lane versus what was submitted? I believe the code is 150 feet. I'm not.
Correct. So there's 150 feet of storage and 50 feet of the taper. Therefore, it will be 200 would be the standard for both the deceleration lane and the left turn lane at this location because of it's a minor collector and the speed limit. But I couldn't tell in their plan, but it didn't look like it was wide, long enough. It looked like it was about 50-50 or maybe 150. So we need to work that out through plan review.
Okay, all right. Also, based on the traffic patterns in the area, and if you confirm, I believe there's going to be 2 entrances here on Morris Road and Hiram Lithia Springs.
I believe it's only one.
Hold on.
Yeah, there's only one main.
Oh, on Morris Road, okay.
Yes.
Okay, so that answers my next question. Okay, Morris Road. Also, in reading the comments, I didn't find where we generally have a stipulation, and perhaps that would be on me to include that for any disrepair of the road that's made during construction, that those roads are to be repaired at the conclusion of construction. I didn't find that in the comments. Is that something typically that we would add as commissioners?
I believe so. We did not make that comment in our comments. And we don't typically make that comment,
Okay.
but you can stipulate it.
Okay, it's just that I saw it come up in some other applications that I had, so maybe that development was a little bit more intense, but okay. That's all I have for DOT. I'll turn it over to my colleagues if any of you all have any questions.
Thank you.
What's happening this morning? Okay. Okay, DOT stormwater and applicant. Okay. I guess I'm ready to start with my comments then. Oh, fire, yeah, of course. Yeah, it is.
Jeff.
It's almost Morris Road.
Good morning. Cobb Fire, Jeff Berg, Cobb Fire.
Good morning, Jeff.
Good morning.
On the site plan, the only access I see is on Morris Road. Is there a second access based on the state law of over 100 units?
Not required. I believe this project proposes 110 units. Code requires a secondary access once it gets over 120 units.
Oh, okay. I thought it went from 30 to 100, I'm sorry.
Yeah,
So it's 120, okay, then there. But they do have access for a fire truck to get through.
Yeah. And a lot of those access concerns can be addressed during plan review.
Thank you. Before I make my motion, I just kind of want to go back and share a little background and some conversations that I've had with both the developer and with zoning with respect to the density that's being requested at this development. Staff recommended deletion to R20 OSC, which I'll also address in my comments when I make my motion. It's currently zoned as R30 with a future land use of VLDR, and that's for very low density residential. The site is 41.45 and has buildable acres of 35.52. The original request, although today's request is for 110 units, the original request was for 129 units, and it was reduced to 110 units, which would yield 3.1 units per acre. With staff recommendation of R20 OSC, that would total 62 units or 1.75 units per acre. So in just looking at some other alternatives, R15 OSC would be 71 units or 1.99 units per acre, which I guess we can round that to being 2 units per acre, which would be at the top end of the VLDR zoning category. But in speaking with the developer and also with zoning, a compromise that I would like to propose, which the developer is amenable to, is 90 units, not 110 as requested before us today. So at 90 units would yield 2.53 units per acre, which is essentially 0.53 units above the VLDR category, and it pushes the development or the parcel into the LDR category, which I think is far more reasonable than the MDR category that's being requested today by the applicants. So while it's 20 units less than what the applicant requested, it's a little more than what the staff has recommended. And in the scheme of things, is 19 more than what the VLDR code allows. On this property, the applicant mentioned that there will be amenities at the property. He didn't go into great detail, but the property will have 16.9 acres of open common space to include walking trails, clubhouse, pickleball courts. I guess I should have started with that one. A fitness center and a reading room. So I think that the development, while what we're being asked to consider at 3.1 units per acre, I think it's a little bit dense, but I'm prepared to make a compromise, which I'll share in my motion. But I just want to thank the developer for their interest in District 4. I appreciate the invitation to join you and the residents of the area earlier this year. I appreciate your ongoing communication with the residents, also attending my monthly In the Zone meetings to answer questions of the residents that were not in attendance in May. So I really appreciate your community outreach. I think it goes a long way with the neighbors. It shows that there will be goodwill in the event this project moves forward. But based on your zoning variance, you are aware that the RSL is not a permitted use in the VLDR zoning district. That category is reserved for 0 to 2 units per acre. And your current proposal request is for 3.1 units per acre, or 110 units. The property is uniquely located in an area that has several single-family residential subdivisions with few empty nester options. And I'm very familiar with this community in this area. When I lived in Powder Springs for 13 years, I was a stone's throw from this location. So I'm very familiar with the landscape and the different residential options in the area. I am supportive of this development and believe that Spring Lake Village will provide residents in the area an opportunity to maintain their independence while aging in place in the community of familiarity. Staff recommendation of R20 OSC is supported by the neighboring subdivision of DeForest Farms, which is also zoned as R20 OSC at 1.75 units per acre. However, DeForest Farm was built nearly 2 decades ago, and the population in Cobb has grown within the past 20 years, particularly our 55 and older community. The applicant's request of 3.1 units per acre would change the zoning category of the subject parcel from very low density residential to medium density residential. As we attempt to address our shortage of housing inventory, and as we are in the process of revising our zoning codes, I do not find it unreasonable to consider rezoning the 41-acre parcel to a low-density residential zoning district. Approving the development at 2.53 units per acre is less than 1 unit per acre greater than the Forest Farm. With that, Chair, I am prepared to make my motion.
Okay.
Okay. I make a motion to approve Z29 to the RSL zoning category with the following stipulations. The maximum number of units per acre shall not exceed 2.53 units per acre. The residences shall be a minimum of 2,000 square feet. The exterior of the proposed residences shall be comprised of brick, stone, stacked stone, cedar shake, board and batten, and hardy plank. All homes within the proposed community shall be for-sale units with a maximum of 10% of the housing being leased at any one time. Applicant agrees to the creation of a mandatory homeowners association. The homeowners association shall be responsible for the upkeep and maintenance of all common areas, open space areas, entrances, and amenity areas. Construction shall be Monday through Saturday from 7 a.m. to 7 p.m. and no construction on Sunday. And construction entrances shall be restricted to Morris Road. Any road or section of the road that is damaged during construction shall be repaired no later than 3 months at the conclusion of construction. The final site plan and elevations for residential and amenity structures are to be approved by the district commissioner. The final landscape plan shall be approved by the Cobb County arborist and the district commissioner. And finally, all other staff comments and recommendations not otherwise in conflict. And that concludes my motion.
Thank you, Commissioner. Are there any other questions or comments with respect to the motion? Excuse me.
Second.
I'll second for purpose of discussion. Thank you. Commissioner, how many, I'm having difficulty with my computer this morning, I think just with the Wi-Fi. How many acres is this site?
41.45 acres.
Okay. And how many homes are they going to have on their property
That they're proposing?
that you're approving?
90.
90, and they asked for 110?
Yep.
And then MDR goes up to 2.5?
Yes.
It's 2.5 to 5.
2.5 to 5. And then under that category will be LDR, which will be
Correct.
less than 2.5.
Right.
Okay. But you're saying that the future land use is zoned at VLDR?
Correct.
Okay.
Correct.
Yeah. So there is a compromise that you did make between those zoning categories. I know we had some correspondence with respect to the zoning density and the considerations of housing affordability, but I think those concerns are also considered within the character of the area, certainly trying to support the need for housing, but also trying not to add housing in that's of significant contrast to the community that's there. So I couldn't put, for some reason, I'm not able to open up the size of the file this morning, but.
Okay. Yeah, and that's a valid point, and that's why, again, I just, I used the Forest Farm, which is immediately south of that development, and that one is zoned R20 OSC at 1.75 units per acre, which was over 2 decades ago. So, we are in the process of revising our codes, and, for that category, I'm not certain what will happen with the VLDR zoning district, but in light of our shortage of housing inventory as well as inventory for 55 and older, I think, or I don't believe that it's reasonable to increase at least to the low-density residential district.
Okay.
Normally, I wouldn't be supportive of going over the VLDR limit, but I understand, the need for this area, and you did make, as the chairwoman said, concessions on the number of units. And with Carl's comments and going through site plan review, I feel confident that they will work out the detention and stormwater management for this so that it doesn't impact the surrounding properties, which are also all VLDR. So I think this would be a good fit. And then I know that there's only one person that spoke, actually in favor, but also concerned about her property. So I didn't know if you wanted to address that or have them address that with her.
Yeah, we addressed that at the top before I began my questions, before I posed my questions to the applicant. They addressed that, and they'll connect with the homeowner. And she shared that for the trail will be shifted, away from Miss Willoughby's property.
Commissioner Richardson?
Yeah, just for the future land use map, what is the property to the south? Because it looked like it had a higher density. Sure, John is looking.
The property to the south is the Forest Farms, and that's VLDR also,
It's also
because the
VLDR.
density is 1.75 units per acre.
Okay, so are all the surrounding parcels, okay. I mean, because 90 is a good compromise. But I was just curious if it was an island of LDR within VLDR.
They're all VLDR.
Okay, thank you.
So we know that the RSL code does not allow development in the VLDR area. I think we are being disingenuous if we think density is going to guarantee affordability. This is going to be a residential senior development, which means all of the infrastructure will be the responsibility of the residents that live there. With the amount of amenities that are going to be here, The HOA fees that are going to be due monthly, you know, the home cost is one thing, but then the monthly HOA fees to maintain this, in addition to the ponds, in addition to the roads, is questionable if seniors can afford. I did like the Planning Commission recommendation better, as I felt it was more in keeping with the area, because if you look at the pictures, the aerials that we have shown, there is no sea of rooftops, which is what we typically hear that people don't want to see. And this area, if you look, still has larger lots in the area, hence the VLDR. So I am not willing to support the 90 units.
Okay, are you suggesting that you want to increase the number?
No, I stated
want
that
to?
I liked the Planning Commissioner
Right.
recommendation.
I understand.
Of R20 OSC. Because while this is catering to seniors, we do have other populations that are looking for, you know, one-story homes, you know, individuals that can't climb stairs or need ease of access. So by restricting it to seniors, you're taking away potential housing options for others. But no, I do not support the 2.53 units per acre
Okay, I
density
appreciate-
suggestion.
Okay, I appreciate that. And just for clarification, I did not communicate or make a correlation between housing shortage and affordability. I'm not saying that these are affordable units. My comments supported the fact that there is a housing shortage, shortage of inventory. When I look at RSLs across the county, I wouldn't necessarily identify those as quote-unquote affordable units. And I don't want to believe that all seniors are in a situation where they cannot afford to live where they are. You know, again, when I look across the county at some of the other units, they're quite pricey. They're quite pricey, and they're occupied, which means that people can afford to be there. But I nonetheless appreciate your comments. And, you know, that's one of the challenges I believe that the developer has in seeking more units than what I'm willing to allow. In my conversations on yesterday, they requested 100 units. But in doing that, would push that into the MDR category. So it is a balancing act to attempt to have a development and still kind of come close to what the current zoning is for the area. And to also keep in mind that we are reviewing our zoning codes. I don't know what the future land use will be for this particular parcel or this area, but when I consider the growth of Cobb County, when I consider the data from ARC, there's definitely a need for there to be additional housing options, particularly on this side of my district.
Thank you, Commissioner, and I will underscore your comments. Our senior population is our fastest growing population that we have here. And I also agree with Commissioner Gambrill that our senior developments are not necessarily the most affordable, but I do know that supply and demand does impact affordability. And the less supply that we do have, the more it's driving up our prices beyond what's conventionally considered affordable. And so I think that's why we had some people weigh in with respect to affordability when they saw the number of units decrease for this application. Again, I'm sensitive to affordability, but I'm also sensitive in keeping with the character of an area, and I think you've done a good job in weighing both of them.
Thank you.
Okay, so again, we have a motion and a second. Any more discussion? Call the question. The vote passes 4-1 with Commissioner Gambrill in opposition. Okay.
Okay, moving on to land use permits. LUP 19, Gonzalo Castillo requests a temporary land use permit to allow more vehicles than the code allows in land lot 143 of the 20th District. The property is located on the north side of Memorial Parkway, west of Jim Owens Road. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to LUP 19? One? Okay, let the record show there's one person opposed. All those who wish to address the board, please come forward and be sworn in.
Good morning. My name is Arnold Castillo.
Good morning. You may begin whenever you're ready.
That's us. We have 4 adults and 5 vehicles, both my parents and me and my youngest sister. And we each drive our own car, and the 5th vehicle being the work van that I do drive to work. So, the reason we're requesting for 5 cars instead of 4 that are permitted is because my dad drives his truck to work, and then I drive the van, and my sister and my mom both go to work, or my sister goes to school. So there's really no more than like 3 cars being there throughout the day. That's it.
Okay. Thank you, sir. Appreciate it. Did we have anyone else here in support of this application? Okay, thank you. Anyone in opposition? Okay, we'll go ahead and hear from opposition. You'll have the same 10 minutes available. You're welcome.
My name is Lieutenant Colonel Terry Madden, retired U.S. Air Force. I live right next door to Mr. Gonzalez. I've got some pictures to show you. Can we put this up? If you're not familiar with Memorial Parkway, it runs off of Jim Owens Road, and that goes into Highway 41 at the Aldi station, the Aldi supermarket. Our road, Memorial Parkway, is typically used as an alternate to get around that intersection. Many people are trying to get to 41. Our road does not have any sidewalks on either side. It's very narrow, okay? Yeah, as you'd like to see here, see if you can get it. I took this picture this morning. We have tried for many years to get speed bumps in. They basically have said we do not have the amount of traffic to have speed bumps. This picture was taken this morning by myself of one of my neighbors taking the effort to try to get the traffic to slow down on Memorial Parkway. It's very narrow. We have children playing all the time. School buses can only get by in one direction at the same time. Many vehicles are speeding down the road. I have tried to get Cobb County to come in and write citations. They will not do it. I even offered to let them park in my driveway. Next photo, please. This is a photo of the neighbor's yard. As you can see, there are 6 vehicles parked there, including a work truck on the left front. There are anywhere from 1 to 2 work trucks there every day. And notice the vehicle is parked on the street. The Cobb County School Board drops children off and picks children off in front of that house. This is an everyday occurrence on our road. And I submit that this is a public safety hazard to the children and to the people of our neighborhood. Thank you.
Thank you. Is there anyone else here desiring to speak in opposition to this matter? Okay, I'm not seeing any. I'll turn things over to you, Commissioner.
Do we have anyone from code enforcement here? No. Okay. Because my understanding is this is a result of a code enforcement violation. If I could have the applicant come back up, please. So you stated only one vehicle was for a work or business-related purposes?
Yeah, the van is for work, but my dad, the white truck that was showed in the photo, my dad, it's like his personal van for work. It's the one he drives.
So does your dad have a business that he uses the van for, or does he work for someone?
He works for someone, but like we're like our own group of like construction, and I like pick people up in the morning.
Maybe a sub.
So are you your own corporation or business?
Not really, no.
So the vehicle that you drive, can you leave it at the company that you work for?
No, we don't have somewhere to leave it, somewhere to put it.
Okay, thank you. The photos that we saw are concerning, given the fact that that road is very narrow, and there seems to be more parking. I understand that there are 4 individuals that live in the home, which is permitted per code. So I would be willing to make a motion to approve the LUP for 12 months for only 4 vehicles. And that would be my motion.
And do you want to add a time frame for them to come into compliance with that?
I can. I was going to kind of wait for discussion before I finished.
If you wanted to amend the motion before a second for discussion, because then we'd have to amend again.
Sure. So I would like to amend my motion to include that the applicant has to come in compliance by October 19th, 2023.
Second and discussion, or wait.
Yeah, go ahead.
John is,
I got one clarification for Commissioner Gambrell's motion. Was your motion for 4 cars or 5 cars?
For 4 cars.
Okay, because they can have 4 right now. The request is for 5 cars.
you're
So they're allowed to
essentially
have 4
denying.
cars and 4 adults right now.
Okay.
The request is for 1 additional car.
Okay, so then actually I would need to strike my previous motion and then make a motion to deny LUP 19. In doing so, that would allow the applicant to still have the 4 vehicles, just not the 5th, correct, John?
Correct.
And so my motion is to deny LUP 19 with the applicant coming into compliance by October 19th, 2023.
and I just have a question as well. So the images showed 6 cars, and so it would take that car away from the road. I know that was what you had included in the first motion for the approval, and so if it went down to 5, everything would still be on the driveway, and you wouldn't have the obstruction on the road. If I'm clear, maybe I'm not.
Potentially, because again, that picture was taken at that time. We don't know how they're normally parked, if they tend to park on the road or not. So I'll just leave it with denying it. That way they can continue to have the 4 vehicles that's allowed by code in their driveway.
I just wanted some clarification on the work vehicle. Is it that it's their personal vehicle that they use for work, or is it a vehicle that's issued by the employer?
We would need to call the applicant back up to answer that. Sir, if you could approach Mr. Arnold. or Mr. Castillo?
Oh, we can? We can? Oh.
Okay. Hi, I just needed for clarification, you mentioned that there is a work vehicle that you use. And for clarification, is that vehicle your personal vehicle that you use for work, or was that issued to you or by the company that you work for? Is it owned by the company that you work for, or is it owned by you?
The van?
Whichever is the work vehicle.
I mean, yeah, they're both owned by us.
Okay.
Yeah, but also I want to add that 6th vehicle, I could think it was someone just visiting. We don't have a car out on the side of the road.
Now, I need to go back and clarify, you just mentioned the 2 vehicles, so how many work vehicles do you have? 1 or 2? Because you just said 2 just now.
I mean, one of my dad's work vehicle, his personal vehicle is a white truck. He drives it to work also. Like, It's not like work.
Okay, so just so I can have clarification, when I ask about a work vehicle, it's not necessarily your personal vehicle that you use to go to work.
One.
Okay, it's one that you use for purposes of work, whether it's traveling to your work site, et cetera. So you're confirming that you just have one vehicle that you use for work,
Yes, ma'am.
not 2?
Yeah.
Okay. Okay, thank you.
Sir, can we ask you some additional questions? Yes, sir. Yes, the 4 vehicles, can they fit on the driveway?
All 5, yeah.
All 5 can fit
Yes.
on the driveway?
That's what we have it right now. 3, because it like narrows and then widens at the end.
Okay.
We have the 3 and then the 2 behind.
Okay. Thank you.
Is there
Oh, sir, you have
carport?
another question.
I think what I heard was your father has 1 truck for work, but you have a truck for work and a personal car as well, correct?
The van is for work, and then the truck is his personal vehicle.
Okay. So he has 2 vehicles and you have 1?
I have one, and my sister, and then my mother.
Okay.
It just seems like there's a work.
I had it mixed up. Thank you.
And just one last question, I'm so sorry, but from the photos, I couldn't determine if there is a drive port at the property or garage?
No.
No drive port, no
No.
garage. Okay, thank you.
This is not, sir, we see you.
So-
I'd ask for the commissioner to call you up.
For me, I'm willing to support this application because I have seen in the past where we've had a personal vehicle for each of the family members and a work vehicle. I'm not sure how long the dad plans to have the work vehicle, and I'm not sure if that's a question that the applicant answer, but I don't think I should have him come back up again. So it just might be temporary, and I just don't know that if he's not allowed to have the 5th vehicle, I mean, I'm not sure which vehicle would be, they would remove from the property, but, you know, with one being a work vehicle and not just 2 personal vehicles gives me a little bit more comfort in having it there. Obviously, the concern is making sure that the vehicles are parked in the driveway and it's not an obstruction, a visual obstruction for the school bus or any other passerbyers. That's all I have.
Maybe just a point of clarification too, because I think that's similar to my question.
Commissioner, I'm sorry, I can't hear you well.
Similar to my question originally. I guess the rationale provided was because of the narrow road. And given that all of the cars can be on the driveway, what is the rationale now? Are we going with the same rationale that they may not put everything on the driveway, or?
The rationale is staff recommendations.
Okay. Okay. Thank you.
Yes, I too am amenable to the work vehicle because we've supported that in the past, and I'm concerned about what challenges could be presented by limiting somebody's ability to work. But I'm also concerned about the obstruction in the roadway, and I think unless there is a no parking sign that's erected, that possibility is there, but in practicality, it is causing some challenges for those that do live there. And so it would be my desire that the applicant be amenable to parking the cars in the driveway, which he seems to be amenable to. If they're guests that come, I think we all may have periodic guests where we reside and they park in the roadway. Hopefully that wouldn't be common practice. But I would just ask for us to be mindful of some of the repercussions that come with hampering somebody's ability to be gainfully employed.
The applicant made no mention of that being a hardship of being gainfully employed if the vehicle was not in the driveway. We also need to go back.
I'm sorry,
and
that's not what I shared. I don't think the applicant shared that the hardship is not being in the driveway. But if that vehicle is being used to work and they're taking people to jobs, I think it can be implied that not having a work vehicle would impact work. But it's not a condition based on it being on the driveway or the road.
But going back to code enforcement, it was 6 or more vehicles overnight daily is the code enforcement violation.
Yeah, I hear you.
I wish someone from code enforcement was here to speak on this, but they're not.
Correct. I think you have the applicant stating that there will be 5 and that there may have been another vehicle, and I think that's worth asking the applicant, because if there's some consideration for going beyond the code, we'll be looking for some consideration from the applicant to keep to what he's stating that his family would commit to, which was having the 5 vehicles. You know, I don't know, what's the length that you can have on a land use permit? It can be under 12 months.
Yes, it just can't be past 24 months.
And you could put in a very tight time frame to see if you continue to see the 6 vehicles out there, if the 6 vehicles is a concern. And again, I would again hate for us to not consider the impact this could have on somebody's livelihood.
Would it be helpful to get some type of testimony from code enforcement? Would it make a difference?
It would make a difference, because again, we can all read, but obviously there was something that brought code enforcement here to then have the result of this. Also, this case has been continued because the applicant didn't show up. The applicant was not present for the Planning Commission meeting. He is here today, which I am appreciative of, but there's other factors in here as well.
Okay. Would it be too much to maybe hold until we can get code enforcement in at the next hearing?
I would be willing to hold it for 30 days and have it be held at our October 17th hearing.
Okay. Thank you.
With the understanding that code enforcement can still go out on site and violate.
Absolutely.
If there's more than 4 vehicles parked in the driveway.
I'm unsure if code enforcement is activated when we have an active zoning application.
In the next 30 days, Madam Chair, the board, code enforcement can go out there and take another look at it. And they can watch this hearing to kind of see what the issues are, to kind of give the board an assessment of what's going on there.
Okay. Can they be cited over the next 30 days?
No.
No.
Okay.
But
Because
just,
their case is pending.
right, so while they can't be cited, code enforcement can provide like a visual observation and share that with the board,
Yes.
correct? Okay.
And that would be helpful if we can, usually we have somebody from community development here, but we can relay that to Jessica. I'm sure Commissioner Gamble can relay that so we can get more feedback.
And answer the previous questions we had too, that were brought up. Thank you.
You can revise your motion.
Yeah, I was about to say, currently, there's a motion that's with a second for denial. It's the board's motion at this point in time. If Commissioner Gambrell is wanting to change that, then it'll be up to the board to do that.
Okay, so I'd like to make a second amendment to my motion to hold LUP 19 until the October 17th, 2023 hearing date, with the understanding that code enforcement will be here for presentation next time.
Second.
All right. Any discussion? Call the question. The motion passes 5-0. Commissioners, let's take a 5-minute break before we go into our other business items, please. Thank you. Board of Commissioners zoning hearing. We are now at our other business cases, and I'll turn things over to you, John.
Thank you, Madam Chair. First case on the agenda to hear today is other business item number 37 of 2023, which is to consider a reduction of required minimum lot size from 15,000 square feet to 14,868 square feet and allow a gravel driveway for Steve Ragus. The property is located on the northwesterly side of Shiloh Road, northeasterly of McCandy Drive, and land lot 215 of the 16th District. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to other business item number 37? Got two. Okay, there's two people here opposed. All those who wish to address the board, please come forward to be sworn in.
So, hello everybody, my name is Steve Ragus. I'm the owner of 690 Shiloh Road. So I bought this lot about a year ago. I was hoping to build a house on it. Actually, my lot is on the right sort of peak of that subdivision. If you're following along, it's sort of the rightmost peak on the south right side off of Shiloh Road.
On the southmost side, off of Shiloh Road.
Yeah, it's on Shiloh. So you're on the opposite side of that property. Yep, you're still a little bit higher, right in the corner, right in that.
Okay.
That's my little corner right there.
Okay.
And I've been having a bit of a dispute with the neighbor that's to my north, that very large property that's 10 acres.
Okay.
So I bought and he is the gentleman that sent in the letter that you guys may have. So I bought the property thinking I was going to build a house on it. There's no house on it today. I went through the process of surveys, engineering drawings. I got permit to build. I started to clear. I tore down an old fence that happened to be between the demising line between me and my neighbor to the north. He comes running over. He's super upset. I offered to repair and replace the fence. I said, let's get our surveyors involved. My surveys say that I'm within my property. Your survey is saying something different. Can we get our surveyors to figure this out? He says, no, no, no. Goes away, sends me this, gets his lawyers involved, sends me this big, huge lawsuit. I get my lawyer to look at it as well. The lawyers come back to us and say, these things happen. It's an older lot. Usually what will happen is you just kind of split the difference. When there's discrepancies in surveys, and it's about maybe 6 or 8 feet is the discrepancy. So on this plan here where the cursor is, it's that north little sectional line that is where my property is, where the cursor is, and that big lot to the north. So there's a 6 or 8 foot discrepancy right there. And usually what'll happen is you just split the difference. And so I'll get to this one. This is what my lot looks like now. And you can see on the north or the top part of my lot, that shaded area is what I've given to the neighbor. Lawyers say we can split the difference. It's about 3 feet each you'll get. I say, great, that's great. We go to the neighbor to the north. He's like, nope, can't do that. I want everything that's mine. I go back to my lawyer. My lawyer says, those guys are just going to fight you all the way. I'm like, okay, well, why don't we just give them everything? We give them everything that they want, the entire piece that they believe is theirs, and if we discover that our lot is 130 feet short, which is, 12 by 12. We go back to him. I say, I'll pay for the fence. We'll pay for the lawyers. We'll pay for the surveyors. We'll pay for everything. Can I have 130 feet? You've got 10 acres. He says, no, can't do that either. So I say, look, okay, we'll pay for everything. We'll give you all the land you want, pay for the fence and the surveyors. Just don't oppose me when I go for a variance. He agreed to that, but I'm not sure if he's here today, but he did send in that letter. And that's the gentleman that sent in the letter. Even though he said he wasn't going to oppose it, he opposed it. So here I am in front of you guys. It's 132 feet. You know, the lot is a buildable lot. It's got water, it's got sewer, all the setbacks are met, everything is fine. All the zoning requirements are met, but for 132 feet. So hoping you guys can help me out. That's all I got. Oh, one last thing that I do want to sort of just kind of reiterate the point that in his letter, if you guys had read it, he implies that he spent $30,000. In fact, I'm the one that have spent $30,000 today to put back his fence. His fence is back. I paid all the legal fees. I paid all the surveyors. We gave him everything that he wanted, and he still is opposed to it. So again, he's got a huge property. It's all wooded. You can see his house from my house, and yet he's still kind of coming after me. So I hope you guys can help me. Thank you.
Is there anyone else here to speak in support of this application? All right, we'll hear from opposition. Yes, sir.
Good morning.
Good morning.
I'm Andrew Phobes. I actually live on McCandy Drive. I border the property on the other side.
I'm sorry, Candy Drive? Oh,
Yeah.
McCandy Drive, okay.
Yep,
yeah.
that's me,
Mhm,
right
okay.
there. You've got
Yep.
your cursor on my property. I've lived there for over 17 years. I was not approached about this, and it's really frustrating that a house is trying to be built on something that it's tiny. All my neighbors are like, are they going to really try to build a house on this property? The other thing is, there's an easement back behind my property that enables that right there to go back to the homes back there. Now, that road in general over the years, I believe, has moved a little bit from time to time. And based upon when they widened Shiloh Road, they did an assessment of the property, and it didn't appear like the lines were correct. Now, I did call and ask about that, but I do have records of the maps at that time that were drawn up. And I believe that the property is pushing that line further than what they were prior. And my concern here is just the community in general. If this property was large enough to build a decent sized home, instead it appears like it's not. And by the way, I would see that from my house. So my contention is that it doesn't help the community. It's a concern for that easement, and it's not something that I want to see out my back window.
Understood.
Okay, thank you.
We'll hear from the next person in opposition.
Good morning. My name is Thomas Hall Fowler. I'm the larger landowner on the other side of where this house is being proposed. And I'll need to clear up some of the erroneous information you got earlier. I found out about someone trying to build a house there when I went to lunch one day, and I look out there and there's a track hoe has torn down my fence that had been there since 1986. Tore it down, wadded it up, thrown it in a dumpster, then had gone onto my property, taken down trees, and actually had done some grading. So at that point, said, you need to stop. His comment was, no, I can go on it. My surveyors tell me I can do it. I said, it's not. It's been there. It's been there for 37 years now. And even when we bought it, there was an encroachment found by the people that did Edgewater East at that time. So there was a lot of errors in their surveying and what they did back then. I ended up having to get a restraining order to get them to stop work out there. Had to hire an attorney, get a restraining order. And what happened after that was a lot of back and forth, I guess, between the lawyers to say that I said, no, I'm not going to take anything. I'm not splitting the difference or anything. That is correct through my lawyer because it was my property. It's been there, like I said, for 37 years. And so it went on, a lot of legal fees. There was a lot of surveying fees. There was forensic surveying done by me as well, title work done. All of it proved to be my property. And we signed an agreement that it was my property and that he did reimburse. He probably reimbursed somewhere around $30,000 between the legal fees for what I incurred. But I still spent another $7,000 or $8,000, like I said, on forensic surveys and whatnot. To the idea that I had said that I would not oppose a variance, that's incorrect as well. And I guess my lawyer or his sub-lawyer said something about the Fowlers may be amenable to not fighting a variance. That was never discussed with me. And I'd be willing to take a polygraph for that. It's just, I didn't want anyone to take the property and to do something on it. This lot, like the other gentleman said, has been sitting there since the early 80s because it's been basically unbuildable. And all the rest of the lots in Edgewater East are built on, but this one. And so, I mean, I think that's pretty compelling evidence that this lot's not buildable. You all know the growth of Cobb County. You've seen it. If there's a lot buildable, people typically get on it and build on it. And this has not been done in close to 40 years. So I think, and then my last comment would be, I'm concerned about the manipulation of the way that he has maneuvered his house to not necessarily take in the front setback he's taken in, but he's now, the house where it adjoins my property, according to his plan, is now a side setback as opposed to a rear setback. If he's on the front and I'm on the back, I don't know. I grew up in Woodstock and didn't have the greatest education in the world, but I think that front and back and then the sides are on either side. So I think it's obvious to me that there's been a manipulation to try to circumvent some of the zoning issues of this property. So I think it's a clear example of an unbuildable lot that was just had a surplus property when they developed the subdivision, and I think it stands that way today as it has been. Thank you very much.
Thank you. I believe that concludes our opposition. John, can you give us staff's recommendation?
Madam Chair, the staff would recommend the board approve the request, subject to allowing the lot to be 14,868 square feet. Number two, allowing the gravel driveway as shown on the site plan received July 31st, 2023, and subject to the DOT comments contained in the other business packet.
Okay, thank you. I'll turn it over to you, Commissioner.
Thank you. Before I get started, I have a question for our county attorney. Since this is in a legal dispute between 2 or 3 neighbors, can we still rule?
My understanding from the presentation that the dispute's been resolved and he gave him the additional property. That's what I heard from the testimony. We can have that clarified, but the applicant gave him the discrepancy property that was in question, and therefore that's why he's asking for it's no longer his property, and therefore that's why he's asking for the OB issue, yes.
Okay, so what I'm confused about is we have a boundary line agreement that Mr. Hall signed, Mr. Fowler signed, dated February 13th, 2023. Does the clerk have that for the record? Okay. Does this, Does this say that he's agreeable to receiving that 138 feet?
The boundary line agreement was signed by both parties back on February 13th of this year, and it was finally recorded last week, September the 15th. And both parties agreed to where the property line would be, which is what's shown on the applicant's exhibit for the reduced lot size request.
Okay. And then, can you go to the other gentleman that spoke, I think Mr. Phillips, the easement, is that a shared driveway where that easement
Yes.
is located?
Yes, when this property was rezoned in 1985, there was an access easement shown that accesses several lots to the rear. And what's shown on GIS, it doesn't comply to what's actually recorded in court to where the easement is. It's drawn to where the road is. But there is an easement that, for the 3 or 4 lots behind this, to access through this property.
And that would be access to the property in question as well, to turn off that driveway?
Correct.
There, okay. So, John, other than the 138 feet, which doesn't meet the R15 code, are there other variances with setbacks and?
There's no variances for setbacks or impervious surface. The only other variance is for the gravel driveway, and that variance is really not for the applicants, for the 3 houses behind them, but that part of the easement is on his property.
Okay. And staff is recommending approval
Correct.
with any conditions or stipulations I need to?
Well, staff is recommending approval, subject to the lot being 14,868 square feet, subject to allowing the gravel driveway as shown on the site plan received July 31st, 2023, and subject to Cobb DOT comments.
Well, all staff comments, not otherwise in conflict.
Well,
No.
DOT had the only comments.
Oh, okay. Oh, boy. Okay, you said it's 14,886?
868.
868. Okay, is there any other comments or?
Commissioner Burrow has one. I'm sorry, Commissioner Sheffield has one.
John, question. This appears to be in the platted subdivision. Is this in a subdivision?
Yes,
That's
so this is the last lot in Edgewater East subdivision that was platted in 1985, and this is lot number 50 in that subdivision.
Okay. And my question is, I know that there is a proposal for a home here, and it's not on us to necessarily view or approve the elevations, but are there any requirements that the elevations have to be consistent with what's currently in the subdivision?
Let me see here.
And if so, would those plans have to be submitted to planning and zoning?
The only condition is the minimum house size is required to be 1,350 square feet. So
And
that's the only
there's no
requirement.
maximum on that?
There's no maximum, and there's no architecture stipulated.
So there was no architectural stipulations for the entire development?
Correct.
Not in 1986.
Right, I'm just asking, because okay, thank you.
But I can't ask that the final site plan and renderings come back to the district commissioner for approval.
As long as, that condition is there to mitigate any negative effects to the neighbors, yes, you can.
Okay. Well, first I need to submit this for the record. It's in the deed book to the clerk. And you do have the site plan? Okay. And then I also want to submit for the record Mr. Fowler's letter through Seamless Documents dated September 8th. Okay. I will make a motion to approve other business item number 42. Oh, I'm sorry. I was making notes on point.
And I just wanted to
I'm
call
sorry.
attention, there was still another question.
Let her do her motion.
Okay, we were,
I make a motion to approve other business item number 37 to 14,868 square foot lot. Subject to staff's recommendation and DOT comments, not otherwise in conflict, and all other stipulations remain in effect, and the final site plan and elevations to come back to the district commissioner for approval.
Thank you, Commissioner. I'll second for discussion. I believe there's some additional questions or comments.
yeah, I know Commissioner Gambrell had her hand, you were trying to say something, and then I had a question as well. Okay. Can we go back to, thank you, can we go back to the GIS, the original GIS view? There appeared to be a lot that was similarly sized and shaped over, wait till it loads. But it's, yeah, it's in the corner of the screen. I was just curious if there was some type of comparative view that we could have on that, on those lot sizes. Yeah. And to the left, it's like a triangle.
Up here.
Up, no, go
Left
up.
of the road.
Take the cursor, it's, yep, right there, that one. Seemed to be of a similar shape and size. Okay. I didn't know if they could, if, I know like sometimes when you click on it, you can see the numbers, but if that's, just wanted to point that out. All right, Gambrell.
Thank you. And then just, John, for clarification, the lots that the gravel driveway would give the easement to, it looks like there's a home that sits on the one further to the north, but not the one directly adjacent, correct?
Correct.
So there could be potentially another home built in this area.
Yeah, and the property keeps going up. There's actually, I think, 3 homes off that road when you go up more.
Okay.
John, are all the other homes in this platted subdivision 15,000 square feet or larger?
Yes, they are.
This is the only one?
Yeah, and when this was platted in 1985, this lot was actually 16,458 square feet. But through the property line agreement, they gave 1,688 square feet to Mr. Fowler. And then through a DOT take, and, you know, we took 84 square feet through a road project years ago.
Did you say 84?
84.
All right, Commissioner, ball's back in your court. You have a motion and a second. Is there any more discussion? Call the question. Motion passes 5-0. Thank you, Commissioners.
Can I do?
Okay, the last item on today's agenda is other business item number 38 of 2023, which is to consider a reduction in required lot size from 20,000 square feet to 8,235 square feet for Tract 1 and the 5,673 square feet for track 2 to allow front, side, and rear setback variances, and to allow the impervious surface to be 51% for track number 1 for Market Hill to Portwood. The property is located at the southeast corner of Pat Mill Road and Lynn Drive, and land lot 157 of the 17th District. Is the applicant present? The director show the applicant is here. Is there anyone here opposed to other business item number 38? The director says no one opposed. Would the applicant please come forward to be sworn in?
Uh-oh. That look. That look.
I'm Mark Portwood. We bought this property at the end of 2021, not knowing that the building in behind, I guess it wasn't zoned for that because it has an apartment on top and a two-car garage. When we went to hook up the electrical, it has a separate meter, and it had one previously. Then we found out we were not allowed to have 2 meters on one property. So we decided to see if we could change, I guess, the zoning on it, so to allow 2 homes on this property and to be separate addresses, and so we could rent it out. So that's pretty much what we're trying to do.
Thank you. Again, not seeing opposition, Commissioner, I'll turn it over to you. I'm sorry, let me back up, Commissioner. We're in other business. John, what is staff's recommendation?
Madam Chair and Board, the staff would recommend the Board deny the request.
All right, Commissioner Sheffield.
All right, if the applicant can approach, I just have a couple of questions of clarification. Hi, you mentioned that you purchased the home in 2021?
Yeah, I think that was December 2021.
Okay, December 2021.
Yeah.
And with the second dwelling, you realized that it wasn't zoned for, I guess it's being, in the past, it's been used as a residence. Are you aware of that, or what do you believe the previous use of the property?
The owner who had it before.
Pardon?
The owner who had it before was using it as a garage. He had a hobby. He built muscle cars, and he had an apartment above. I don't know if it was being used while he was the owner as an apartment, but you can walk up the stairs and go into the apartment on top, and then all the bottom is open that he used to store his cars and car parts and stuff like that. When we bought it, the power was on, and it was built, I think, in the 1980s. And it shows on all the legal documents that that building existed. And so after the afterthought, we assumed that it was allowed to be because it was shown on the property. So we didn't understand why it was working before, and now we can't use it.
I see. Well, before I address that, can you share with us what your potential or intended use is for the building?
Well, if we had approval, I would like to divide the lots and improve that building as a home.
Okay, so you're looking to split the lot and have 2 separate deeds and have, and I guess maybe, renovate or just sell that property?
Well, we'd renovate it to accommodate, the ability to live in it.
Okay.
It has a separate, driveway off of Lynn, and so it wouldn't conflict with the other home at all.
Right, okay. The tax records reflect that there are 2 structures on the property, but it does not indicate that both structures are a residence. or separate property for purposes of a tax ID. And I'm assuming you're aware of that, and that's why you're before us today to split that lot in two. But if you would, just describe to us a little bit more the interior. I saw some photos on my MLS last night, but I just wanted to give you an opportunity to share with the board the interior of that second building.
Okay, as you go in off of Lynn, there's a two-car garage. And if you go to the left of the building, there's stairs going up to an apartment. It's a one-bedroom apartment with a kitchen and a bathroom and walk-in closet and a living area. Below that, it's just open space. It's built on a slab. It has its own separate sewer line going into the sewer. It has its own separate electrical hookup. The only thing that's kind of shared is the water coming into the building and the gas line.
Okay.
It's piggybacking off of the house, and we wanted to separate that out also.
Okay. When you viewed the property with your agent, did your agent share to you that that building was in fact a garage? And not a
They just
residential
showed us.
dwelling?
They just showed us the property.
Okay.
And, obviously, when they showed it to us, the owner before was still living there. And he had his little shop there that he was building cars and stuff like that.
Sure.
But we
okay.
viewed the whole property, and we didn't think much other than, gee, this would be a great idea to renovate it or rent it out.
Sure. No, I understand that. I was just curious about the showing because I pulled the property on the MLS last night, and there was a description which is also visible to the public. So in MLS, there are private notes for agents and brokers, and then there are public notes which the public have access to. And in the public notes, it indicate that the building is in fact a garage, and it went on to describe the number of bays, et cetera, and that it would be a great place for hobbyists to repair cars
Right.
and things of that nature. So I was just curious to know what information your agent shared with you about the property. But you've answered my question.
Yeah, other than that, I mean, it is obviously, it's for hobbyists, for their cars, it's perfect for that. But, there is an apartment above the garage in the back that you could rent, fix up and rent out.
Okay. Okay.
But ideally, we like to be able to split the lot and improve the building, so you could be living upstairs and downstairs and still using a two-car garage.
Okay, I see. Okay. And John, let me just cut to you. You and I talked yesterday, if you can just confirm for the record that we did not find a certificate of occupancy for that second dwelling.
Correct. And I even searched for any variances for it. I could not find any variances for that structure either.
Okay. Okay. Do you guys have questions?
My understanding is they also have connected to sewer and water. Do we have any record that sewer and water approved that connection?
As far as I know, it's still on the account for the main house. It doesn't have a separate account for water and sewer.
So if this is split for two homes, are they going to meet the R20 requirement?
No.
No, is that why staff's recommending denial?
Yes, the lot size reduction for the back lot where the two-car garage is, that would be a 72% reduction over what
Yeah.
R20 requires. And just by comparison, the one we just heard was a 1% reduction.
Right.
That kind of made sense when you talk about the deeds and the property dispute.
All right. Okay.
And then one other, has the fire marshal even inspected to make sure that the structure is safe to be inhabited. I don't know, do we have any record that they've inspected?
It was part of my process in preparing for this, Commissioner Gambrill. I did try to find some building permits for this, and I could not find any building permits. And that may be because it's just so old, we don't have those anymore, but we do not have any records of this building.
Any other questions for the applicant? No? All right, you may be seated.
May I speak? My name is Hilda Portwood. Now, we got 2 homes in the property, okay? And the first home we rented. Now, we need kind of do some income for the second one. So if you guys don't approve it, what can I do to make an income from that house for us?
Understood. We understand.
Did you understand my question?
Yes, ma'am.
Yes.
Because the house sitting there not doing anything.
Exactly.
And it
But-
has some potential. And if you divide it, not only the county get benefits, because you can get another tax, and we have another house, another property. I look at that way. You win, we win too.
Thank you.
Right. Thank you for your comments, and we certainly appreciate and understand that going in, the thought was that you might be able to split the lot, and from the sounds of it, you were looking to sell it. So you were probably looking very much forward to doing that, but what you're asking us to consider is a bit it's a bit draconian for what we typically deal with these type of requests. So,
Okay, thank you.
thank you.
Yes, I mean, unless you want to stand here and,
No, I just
have a
wanted to address her,
conversation.
but thank you, ma'am, for your comments. You may
Okay,
be
so-
seated. Thank you.
Thank you.
So the subject parcel is zoned at a 20,000 square foot lot, and the breakdown for both Tract 1 is proposed at 8,235 square feet and Tract 2 at 5,673 square feet. So combined, the total is just 13,900 square feet, which is 6,092 square feet less than what's allowed in the R20 category, where with the previous application, the request was for a variance for 132 square feet, which does not seem unreasonable, but we're asking a reduction of 6,000 square feet, which is more than the square footage on Tract 2. If approved, Tract 2 will increase the impervious surface from the required 35% to 51%, which is more than half of the lot size. As I mentioned earlier in reviewing the MLS comments, it was marketed as a, and I quote, "a detached garage with 4 bays, a garage apartment with an open living room, kitchen, 1 bedroom, and 1 bath, and a huge closet." Those were the comments in the description on the MLS listing. And based on the MLS description and staff recommendation, I support staff recommendation for denial, and I am prepared to make my motion, Madam Chair. I make a motion that OB 38-2023 is denied, and for the structure to be utilized for what appears to be an intended use of a garage and/or storage. And let me ask Bill, with my denial, am I allowed to include that last sentence or no?
Say
Or do
what
I just
exactly
need
as
to
you
do-
want.
Pardon?
Say exactly what it is that you want.
In addition to denying it, my request is for the structure to be utilized for what it appears to be an intended use of a garage and/or storage unit, and no residential living at the property, but I'm not sure if I can add that with the
Yeah, I don't think you could
denial.
add that. It would just be a matter of code enforcement.
Okay,
Be able
all
to
right.
look at it and review it for, if it doesn't have a CO, then living shouldn't be allowed there.
Okay, all right, thanks.
Second.
Are there any other comments? Yeah, I know this has to be a disappointment for the applicant when you purchase the property. Just from looking at the Google images of that site, I mean, it is certainly appears to be built comparable to a home beyond a garage, but for reasons shared, I'm in support of the commissioner's decision to split that lot into 2 residential lots would be out of character with what's in that area and what that lot is zoned for. And I can only imagine the disappointment you have with that. But with that, I'll go ahead and call the question. The motion carries 5-0. Let's see. Which one? OB 38. Oh, that was OB 40. Oh. Okay, yes. I see the gentleman had his hand up. Why don't we go ahead and take a 2-minute break, and you can approach, and if you have a question, talk to the commissioner.
We're done.
Oh, OB 40 was, I didn't cross that up? Oh, okay, great. Thank you. Okay, our zoning hearing is completed at 11:30, 11:32. Thank you for tuning in, and sir, you can feel free to approach the commissioner. Thank you.